protecting defendants' minor children is an element that is tangential to the second limitation. There should be no visual audio coverage of any pretrial proceedings, including but limited to bail hearings, arraignment, pretrial or omnibus limitations, motion in limine, and other things prior to being sworn. Any hearings take place outside the presence of a jury. The matter is scheduled to come forward in contested omnibus. Both the timing of Mr. Moon's motion as well as the request the court permit audio and visual recording of all future proceedings strongly suggests he seeks the court's leave to record and broadcast the contested omnibus, not just the trial, should the matter be dismissed or two. Yeah, I don't think the omnibus is going to be, if this is a law, the one thing I will concede here is if this is an accurate description of law, we may not get the omnibus hearing. We may just get the trial, which would incentivize Nick to settle because the trial is what would be really embarrassing for him. The term shall is mandatory. The court has no discretion to grant its motion for any proceedings prior to the jury being sworn. So they can only grant it for the jury portion. His lengthy analysis is irrelevant. Because the plain language of Rule 4's limitation renders his analysis of general factors superfluous, the court need not consider them. Nevertheless, due diligence requires to be specifically addressed. No, that's not true. And this is his lawyer trying to pass it off with the children argument, which doesn't fly, right? Because he's trying to specifically talk about the rule pertaining to children. Okay, the defendant does not favor video action. So they're literally saying right now that the defendant does not want audio-visual access. So no matter what Nick wants to say in his filing, which at the end of the day, we judge people by their actions, not their words. People can use all sorts of weasel words and do sorts of things, but we judge them by the way they behave. And he signed off on this. Nick endorsed this. He endorsed a statement that says he does not want this to be televised. He wants to hide. He endorsed that. Oh, from silence, Mr. Moon assumed the defendant's position on video access to the court has not changed, so he hadn't received a response. This is a bold assumption, as cited cases upon which defendant has previously opined did not involve this, nor any of the other defendant's minor children. So Nick is making the argument here is that Nick has committed a victimless crime. Nick is making the argument that neglect, use, possession, victimless crimes. The level of public interest is concededly exceptionally high. So they're going to contest this, right? They're going to contest this. It is that exceptionally high public interest, as evident in the defendant's first appearance, which resulted in public interlocutors intruding upon the proceedings, as well as proceedings being recorded by parties as yet known, unknown, and made available on social media. Okay, so they're literally trying to equate a trial with, in essence here, a first appearance. They're two different things. The trial, we've already said, look, the pretrial stuff shouldn't be recorded, but the trial is the public proceedings that everybody should be able to attend if they want to attend, right? The first appearance was just the first appearance, and that was on Zoom. And honestly, the only reason why that got interrupted is because some boomers didn't know how to regulate Zoom. You can literally manually unmute people. According to the U.S., guarantee a right to trial by an impartial jury. According to the U.S. Census population, the population, I guess he is assuming, of Kandiyohi County is 48,000 people. Of this population, 24% are under the age of 18 and 21% are over the age of 65. That leaves a pool of 26,847 adults, most from whom to seat a jury. Neither the defendant nor the court can undo the unlawful exposure to which he has been exposed, tainting his potential veneer. But defendant does request the court can prevent the harm to his future right to an impartial trial by not tainting the potential veneer in a venue this smaller than that drawn upon in Chauvin. This argument applies to the majority of counties in the United States. If Nick is saying that, it's going to taint the jury pool, then every single trial was tainted. Then so was Kyle Rittenhouse. So was Johnny Depp. Every other jury trial was tainted by recording. You really believe that, Nick? Nick just said, I want to get back to trial streaming. This is what Nick said recently. There's clips of it. He's talked about it recently. He said, Nick just wants to get back to trial streaming. You dare to go back to trial streaming after you say this, that it violates your right to trial by an impartial jury? The coverage is not necessary to ensure a public trial for the defendant or to protect their right to access. Even if the court denies the motion, defendant's trial should the matter be not dismissed prior thereto, will be public and the public will have the right to attend. Only they may not be able to attend from the comfort of their recliners in their pajamas. The point is that there are people around the world that are interested in this, or people that are around all the United States that are interested in this, right? And yeah, not everyone wants to go out to Candiotty County, Minnesota. I don't. Right. But that said, Nick goes on to compare himself to Trump. Literally, Nick and his lawyer think that he is Donald J. Trump. Look what he says here. Earlier this year, Donald Trump was tried by a jury in Manhattan. Despite the international interest, the inability of those accredited journalists who desired to be physically attend and offer commentary, President Trump still had a public trial, and the public had the right to access, even though proceedings were not recorded and broadcast. Well, so he's not just calling himself Trump. He's saying that New York law should be the law of the land across the United States, because that trial happened in New York. Nick is saying that the authoritarian communist rules of New York are good law for all of the United States. He's pro New York here, bro. While the defendant does not claim to garner the same interest as the former president, I'll take that step back there, huh? And recognize it's a different jurisdiction and venue, the general rules should be universal. Literally saying, take New York law and make it universal. Security issues and facility limitations do not require broadcasting. Counsel for Mr. Moon says there might be overwhelmed by thousands who desire to attend. Mr. Moon's counsel may well demonstrate that there's interest, but has offered no evidence to support any assertion that thousands of those are interested enough to transmit a data request or sign an online petition will flock to Candiotty County Court, overwhelming the facilities. Even if every individual who took effort to execute affidavits elected to attend in person that would not fill the court. Mr. Moon's counsel offered no argument to support in his conclusory statement that security is beyond the measures of Candiotty County sheriff's deputies who secure the courtroom. Yeah, I think that the sheriffs could probably handle it, except for there'd be too many people. I think the facility issue is the bigger thing. Mr. Moon's counsel is aware of no technological or other infeasibility of granting this request to audio-visually record and broadcast. Mr. Moon's counsel does not aver that to know if the facilities are conducive to the method he proposed. The method is simple. Press record, bro. The method proposes leaving open broadcasting for minor children. No, it doesn't. When did Josh say he wants to explicitly record minors? And it's not allowed. This is bullshit. And I hope their counsel responds on this. And it's like no one is, because they need to just defeat this argument. Right? Nobody is asking to record the children. This is ridiculous. Broadcasting these proceedings are unlikely to promote transparency, public education, public trust, and confidence in the proceedings. Guys, he is literally saying, hold on, this last point here. Nick is arguing that streaming trials does not promote transparency, public education, public trust, or public confidence. He is arguing in that last statement that it is a net negative to stream trials. He says these factors were lost when members of the public ignored the entreaties and orders of the court to conduct themselves with decorum. He's speaking about the fucking Zoom hearing that the boomer judges didn't, like the boomer staff didn't even know how to operate properly, right? So literally they're saying when they spoke up and they were rude during his first appearance, they lost it. So if we allow recording, it's like punishing a child who raided the cookie jar by giving them the rest of the cookies. It's insane. And this is, once again, Nick Rekieta had to endorse that motion in its entirety. If he did not endorse that, his lawyer could not legally file that. If Nick did not endorse those arguments, it could not be filed by his attorney. So he must have endorsed that argument.